respected distinguished guests present today and distinguished faculty members. This conference, good afternoon to all, I hope everyone is awake post-lunch. This conference and the paper that I have submitted has helped me to find an answer to a question which was asked to me in every interview which I gave as a fresher. The question was, why management or why MBA? That is, why did you do MBA after 5 years course of law? Because I did my MBA after 5 years course of law. So every time this question was asked to me, that time I used to somehow try to establish connection between law and management, but could not impress the recruiters. So tired of the question, once I responded to an interviewer that I had pursued management because of music. If law is an amplifier, management is an equalizer. Surprisingly, that answer was actually out of frustration, but surprisingly, the interviewer got impressed. So much so that he was a law firm, the partner started discussing with me the business of their firm. So what are the different areas of practice they are in. While deliberating that, because I had done MBA recently, so that BCG matrix is one concept, it was fresh in my mind. So it is with respect to product placement. So you identify your growth of the product. So I, on a whiteboard, I neatly in a diagram, I explained them their own products. So I told them that arbitration is probably your star product. Your due diligence practice is your cash cow. DRT practice is probably question mark, and so on and so forth. So that is how I gave responses to various interviews I faced and this question of why management and MBA. In that interview I was selected by them, but I did not take up the job because I saw that they were looking at a salesman in me more to expand their business rather than a lawyer, and I wanted to become a lawyer. Though I did not take up the job, I started thinking from that moment there is link between management and law. And I can answer the question why management today. Management because it helps me advocate my client's case in more organized manner, advise my client on remedies more pragmatically than theoretically, take any result, whether favorable or unfavorable, sportingly, and find solution. There is always an opportunity in every result. In law practice, enactments and precedents that interpret the provisions are Bible for the lawyers. Litigation ultimately is a process. Using these precedents and enactments to the advantage is where management as a subject is helpful. What I have tried to portray in my paper is only tiny bit of how management can marry law. In the paper, so far as law is concerned, it is defined as logic, arithmetic, and wisdom. And the perspective of management is process that controls and administers. Actually, I was hoping that the papers were there before you. I did not know, so I scribbled few things and immediately gave this PPT to them. So this is also part of management. I have given some instances also in my paper where change in environment affects your litigation process. There was a presentation in the morning I noticed where change in environment affecting business was also deliberated. But change in environment affecting the legal process, the litigation is also very important. What are those kind of changes? See, overruling a settled judgment, it changes the scenario, it changes your litigation process. Today you are planning something and suddenly new judgment comes. Recently this BCCI issue is also going on, so suddenly they have now changed their stance, they have to. So these are how the environmental factors affect your litigation process. And at micro level also, like change in assignment, like because I am a litigation lawyer, I can tell you, change in assignment of a bench, suddenly, it also changes your strategy. Because some judge may be liberal, some bench may not be that liberal, some bench may be very fast, receptive, some may not be. So those are also change in environments which affect your litigation at micro level. I have given some instances of change in environment, like the case of Dashrath Singh Roop Singh Rathod finds reference in my paper, where the litigation with respect to Negotiable Instruments Act underwent a change. In such changing environment, strategic management of remedies becomes important, because there are plethora of instances when the remedies are multiple. One has to assess provision or precedent that impacts your litigation, in what manner it impacts, that is also important. So assessment of impact requires proper decision making. Because ultimately provisions are open to interpretations and precedents can be multiple, leaving multiple choices to be made. Now, decision theory is essential for understanding this phenomenon. If you notice the diagram, as you gather more knowledge, the certainty increases. Now, sometimes, because of the ignorance, we see per incuriam judgments. That is because of ignorance of law. Similarly, I have given instances of per incuriam judgments in my paper. I have also dealt with obiter and other theories of precedents, relating to precedents. The judgments of Mohandas Isardas versus A.N. Satanathan and Asia resurfacing of road agencies versus CBI are reflected in my paper while discussing the obiter. Now, after understanding the nature of decision making, it becomes important what are the methods of making a decision. Now, this is, in the paper it is more neat, okay, in my paper presented, this is just a rough sketch. So this is decision tree analysis. With the help of decision tree analysis, we can actually document how you want to proceed with a litigation, how you want to strategize a litigation. That is where management comes into picture, management principles comes into picture, and health law. And such kind of documentation is helpful because in future, if you are faced with similar litigation, you can rely on that documentation. Now here it is just a example. So this is decision tree analysis, this is decision nodes, decision rank, this is the theory from the management principle. Now this is its application in our litigation. So if you want to institute criminal proceeding, how decisions you will make? So one option is to approach police, the other is to approach magistrate, then police decision, if police refuses to register FIR, what are your options? If it registers FIR, then what goes ahead? All those things. So this is how you plot it. And the benefit of plotting it is, if you become wiser over a period of time, you can again change and revisit the nodes, the chance decisions, etc. In conclusion of the paper, I have made certain suggestions with respect to testing, contingency management, forecasting, and budgeting. Now, for corporate houses, These are certainly possible things because usually corporate houses and law firms, they work in a team. With manpower in place, testing through mock courts, like you do moot courts in our law colleges. Similarly, sometimes mock trials can also be done. That will give you an edge over the competitor to know what is the likelihood of the result given the precedents and the provisions that are existing. Mapping the strategies in decision tree would give clear picture of contingencies also. So what happens if not this? And further remedies available will be open to you with due consideration to the precedents and the provisions. All these things ultimately would help in clearer picture about where the litigant stands, and accordingly the litigant can prepare the budget for his litigation. So he will know whether I should actually invest in a litigation or stop there. Last but not the least, before concluding in the paper, I have also dealt with judicial behavior. Know thy judge is an essential principle one has to follow. In the paper, reference is made to Richard Posner's theory on judicial behavior. Of course, the evaluation of those theories, because he is an American author, evaluation of those theories is not foolproof. Indian context on some occasion differs. For instance, when Richard Posner in his theory is dealing with some case of sex discrimination, he says that it will impact if the bench is largely having female judges, and it will be decided otherwise if male judges are there. But now you see in Indian context, everyone knows Sabrimala case. Only minority view was given by a female judge. So always background of the judge is not to be taken for granted. You should not be influenced easily by that also. Now that is the reason why it is essential to look towards litigation from broad and different perspectives, and management comes into picture there. In any way, judicial behavior is important as a study because precedents are outcome of humans' wisdom, whereas legislations are outcome of humanity's wisdom. With this, I thanks for accepting my paper. Thank you very much.